Hey, when we walked in, the two main ones ran. Teapot and Brandon Kimmel, the one that arrested me. Both of them was right there. As soon as they saw me, they both ran. Brandon Kimmel, and Teapot.
Mahomes, he's going to be week to week with that ankle. They said it's
week to week, so he might not play next. Is it next Sunday?
I didn't know what it was. It was an ankle that he injured.
Yeah, it was an ankle. I saw the play. It was an ankle. He was running it, tackle. So they said that the X-rays showing.
Hey guys.
He could hardly walk. Into the game, he could barely walk.
Oh, I don't think I put the. I don't think I put
Denver won.
Yeah.
We did good. We can go, Bo, next.
So we're at Mr. Gold's hearing, the same judge that arrested. He's not here yet. He's going to be. His lawyer's going to be here, but he's going to be. He's in California. They're trying to arrest him. So.
Oh, they're arrested here.
They put another thing on him. It's all bullshit stuff, you know. They keep bringing stuff back. Because like when I pull up here, when I pull up here, the last 2 days, there's a guy back there, like I was telling him. There's a guy catty cornered every time I pull up here. The last 3 times, it's yelling. You have my cassette. You can put it on me. Yeah, you have my cassette. Hey.
You can record, but you can't record on the floor.
Yeah, you can. Yeah, you can. Hey, right there. Hey, show them that papers. You can.
As long as you have our consent.
I have everybody's.
Are you going to arrest her?
And he works for the court, so you can record him too. I'm telling you.
You like it?
I almost wore my Tucson police.
Yep.
Sure. But it was too
See, they're trying to tell her she can't record, and she can. See, look at the view up here, guys.
It's great.
This is the view. It's a good view. It's better on the top floor. Hey, remember Dick?
I mean, we're all in public, so if they don't like it, they can go in the house and close the door.
Yeah.
As long as you give me consent.
Yeah.
I'm in America.
Yeah. Yeah. And I agree with her.
Number 1, and I have number, I think it's B. So,
Hey,
we're gonna.
hey, remember he's with us. He's not a court guy.
I'm the big one.
He'll give you his permission. Was that? Yeah.
I am West.
So Dick Tracy already tried to tell her she can't.
Oh, that was Dick Tracy?
Yes,
Oh, okay.
Mr. Tracy.
He's sort of like the head of all the palm tour. He's at the superior court.
See.
You need to find something better to do, or you can't.
Well, see, he doesn't. So he'll do that to people that he knows that he knows it. You notice he didn't tell me that? He told you that because he thought he could scare you. He just didn't understand who you are. Is it started? I'm going to go inside the courtroom. Yeah.
Application to dismiss without prejudice based on prosecutorial correction. Counsel, any objection to that? No, Your Honor. Counsel, here now grant that motion charged to dismiss without prejudice. It will be closed. The other matter, we're set here for a status conference, so there is pending before the court then pro se motions to dismiss as well as the state's response thereto, and then a reply from the pro se defendant. That was all happened then before then counsel receiving the filed last week. in a position to argue those motions? Do you want to proceed with that?
Well, at first, I'd ask the court's inclination. I do think that there is some merit to some of the points, but I think I could probably put a finer tip on those motions. So if at this point your inclination is being to deny those motions, I would just ask for the opportunity to file an amended motion. We can argue it down the road.
When we last spoke, it said for the status conference, and the court was, after receiving the motion, going to determine whether or not it's going to hold oral argument on them. That was my inclination to hold the oral argument.
I could proceed today if your inclination to consider those arguments. I do think that there are some serious concerns raised with the discovery in this case, and I'm prepared to argue that if the court doesn't bear argument on that at this time.
Okay, Mr. Joseph?
Yeah, so I'd just like to point out that Rule 50.6, which kind of governs the motion, even though it's not cited directly in the motion, Rule 15.1 and 15.2 are both cited. And when we're looking at sanctions for a discovery violation, there are a few things that the court has to consider, including how material the information was that was withheld, the reason why it was withheld, and any prejudice that it may have caused the defendant. Here, it should be noted that the incident date for this case was back in September of last year. This was charged by long form. The rules require that discovery is disclosed at the time of the arraignment on misdemeanor. The state was not given a reason why it was not disclosed at that time, and was given no reason why it was not disclosed until October of this year. That is extremely delinquent, even by, felony standards. So we'll be getting this case discovered 10 months in. I also have some concerns because there was a significant amount of negotiation going on in this case by the form of a diversion agreement or prosecution agreement. My understanding is that Mr. Gould wished to see some discovery before entering into that agreement. That agreement was ultimately revoked before he had an opportunity to see the discovery of this case. Now, as far as the content of the discovery that was not disclosed, it is the audio recordings that form the basis for the disorderly conduct charges. And I also think it's material that it's not just 15.2 materials that were withheld, there's also written materials within there. There are comments made by the investigating detective that seem to suggest that he did not believe that there was probable cause for some of the noises that were made because there's no indication that it was Mr. Gould himself. Ultimately, this case was charged by long form based on the fact that the victims could recognize his voice. The detective described the cries as distant. And ultimately, he was also charged for other noises that are in the background, for which I still have not seen probable cause. So as far as the prejudice it causes to the defendant, of course, we can't argue that he's prejudiced at trial because trial date has not been set, but that does not mean there is no prejudice. I think there is significant prejudice that this case lasted over a year, and he was not allowed to see any discovery. And courts, including on my cases in the past, have found that it's appropriate to dismiss without prejudice where there has been a significant delay in the discovery to allow both the defendant a chance to have some vindication for the rights that were violated, but also for the state to have a chance to relook at things because apparently nobody had been looking at discovery in this case for over a year while the deferred prosecution was being negotiated. So I do think that some sanction is appropriate. I would be asking for dismissal without prejudice at this point of this case. I don't think it's good enough to simply say, we apologize, it should have been disclosed earlier, but also there's no prejudice, so there should be no sanction. I think there needs to be some sort of sanction. In the alternative, I think that any and all disclosures that are untimely should be excluded from trial.
So, counsel, then, even though I know now you're the third attorney who appeared on behalf of Mr. Gould, that it's my understanding of the usual practice of the county attorneys, once they make the diversion offer, they actually usually don't send disclosure and puts almost an unofficial stay on the matter, if that makes sense. So should that time then from when the first diversion offer was presented to the defendant at the first case management conference, then until it was revoked sometime in August, be excluded from the court's calculus of how long there was an alleged discovery violation?
The way I read the rules, the time is stayed after a motion to suspend prosecution is filed. At the point that the first prosecution is being negotiated, the way I read the rules, that really time continues to accrue. I think especially where there's a discovery violation, there's been continued, and I went through the communications, repeated requests for that specific discovery over the course of months. This wasn't something that was looked past and it didn't get brought up until just before the disclosure. I had communications going back to the summer requesting this. So had a motion been filed and the case actually been stayed, I would agree. But I think that the rules require that really time be included. Now I know that there's former records, and I'm sure there's been prior waivers in the past, and I'm just giving the court my position on the legal issue.
Great, Councilman, can you avow when the first request for disclosure was made, even as a part of the negotiations for the diversion offer?
I cannot about this time, as I hope to put a finer point on the motion, which is why, you know, it may be appropriate to have me fully flesh out the legal arguments, and we can have subsequent argument, but that is what I'm prepared to present today.
Thank you, Councilman. Mr. Wilbur, response from the state.
Your Honor, for the most part, we would refer to everything stated in the motion and would request an opportunity to respond. However, our main argument would be that dismissal is not an appropriate sanction at this time. And additionally, as Your Honor stated, the Rule 8 time should be stayed due to the informal diversion offer, which was for the benefit of the defendant, not the benefit of the state, and as such, it should be included.
Mr. Wilbur, when did the state then make that first initial diversion offer? The state's looking at that. No way you could really find the information of when the first request for that discovery was made.
My file is very piecemeal, and it's just what I've been able to gather from the client, so I'd not feel comfortable about into that at this time. But I do have one, if the court will hear me on the diversion matter, one thought to share. If the state's, okay.
Let Mr. Wilbur finish, you'll of course get a chance to respond.
Thank you.
Your Honor, at this time, I don't have the exact date, specifically because I'm simply covering today. However, if the court would like that information, the state could provide a supplemental motion.
Mr. Wilbur, the state's position then on, I don't know, for example, might be making Rule 8 versus Rule 15, so sure, say the court then finds that the initial diversion offer went out and then it is for the benefit, so maybe Rule 8 time would be running, but certainly then when the state still has to comply with Rule 15, until then a formal notice to suspend was filed.
Your Honor, we would argue that it is typical of us when we go down the diversionary route, disclosure and contesting the procedures are not generally done. Therefore, disclosure doesn't typically happen, and that's generally stayed as the case going to be dismissed anyway.
So I appreciate the county attorney's policy, but I'm asking more of a legal question of should the state still be held to Rule 15, even while the informal negotiations are going on?
Your Honor, we would argue that it should be stayed as well, due to the benefit of the defendant, and if they complete diversion, the case will be dismissed, therefore there's no need for disclosure at that time, as they're going down the route of dismissal rather than contesting the charge of the middle of the trial.
But what if then we were to credit then counsel Val that there had been a request during that time that before I take the diversion offer, I want to see the discovery. Would that then, in the state's opinion, re-trigger 15? They still have to comply? And if you have any precedent for the fact that 15 would not apply if there are informal diversion negotiations?
Your Honor, at this time I have no precedent, however, we would just request the opportunity to respond by motion.
So then you're requesting then a served response based on the fact that you're understanding that such an argument was not brought up in the original motion or reply?
To be completely frank with the court, I have not read by the motion. This is not my case, it's Sam Walker's case. Therefore, any additional requests from the court regarding the legal state of the case or the factual basis of this case, I would request an opportunity for Ms. Walker to respond or potentially set the decision oral argument, defense counsel mentioned, to the parties the opportunity to revise their motions and set the current oral argument.
So I appreciate you just covering forward, and Swagger would have anticipated being here today. Of course, everybody would be appearing then as a deputy of Ms. Lorcana, but is ultimately then responsible for having an attorney here present in the courtroom ready to proceed with the proceedings. The court has informed the parties that we would like that oral argument was going to be held today, so they did have notice of that, despite it being classified as a status conference initially. Nielsen?
Yeah, I have 3 points to reply to. The first, I did attempt to reach out to Ms. Walker last week to discuss the contents of what my argument would be and the motion to see if we could come to some sort of resolution ahead of today. The second thing I'll bring up is as to the diversion. The issue I have with the state's position is they want the benefits of the rules under diversion without actually agreeing to the terms of diversion. I hear the state essentially arguing out of both sides of their mouth, and I don't mean that to be personal, I mean that, as an analogy. What they're basically saying is that he had the full benefit of an informal diversion offer. It's my understanding that he engaged in mental health services starting in January. He listed his house for sale, however, I personally feel that diversion term, it was in all 4 of the diversion agreements. I see that he substantially complied with the diversion offer, and he simply wanted to see some discovery. I then know that he was instructed to appear telephonically on August 1st and ultimately was not able to get into that hearing, and then the state pulled the diversion offer. So what I'm hearing from them is that they're both acting as if that diversion offer was open and he was benefiting from it, but also he did not reap any benefit from the diversion offer, and it was pulled, and the basis it was pulled is that the state felt that they did not believe that he had made any effort to comply with the informal agreement, and that was the basis for pulling it. I have an additional motion I can file under Cranmer to that, which is a Division 2 case, which deals with whether or not the state can abuse its discretion to pull a diversion offer. I hope to speak to Ms. Walker about that beforehand, but I'll just go ahead and prepare that motion. But I think in any regard, the discovery violation itself, which is my third point, needs to have a sanction. Rule 15 does not make a carve out for any sort of diversion offer, informal or formal. What does suspend the requirements is if a motion is filed by the state to actually stay the prosecution in the case. That is the only rule under the Arizona Rules of Criminal Procedure that can actually relieve them of their obligation to make a disclosure. That was not filed in this case ever, which means that their continuing obligation to disclose discovery bound the state for the entire year of this prosecution. And that's not to mention the fact that in long form cases, we often expect the discovery to happen initially because they had 4 months to decide whether or not they wanted to charge it. They had all the materials. The detective sat there and reviewed the materials with the county attorney's office. So I know that they had access to them. And then they simply didn't disclose them for 10 months. And there has to be some sort of sanction for that. The rules are doing any of that.
How did you have a site for that Cranmer case?
Yeah, I can get you a short site for it. Please. Give me a second to pull up the last one. Certainly. That is 204 Arizona 299. Cranmer v. State, Division 2 case.
Thank you. That could certainly be distinguished on the basis that it was a formal acceptance of a diversion agreement and then the alleged breach of the agreement rather than there being an extension of an offer that then was withdrawn, that the defendant actually, unless on the state council, you're not arguing that the defendant has a right to that diversion offer.
No, I am arguing that. My contention is that the material portion of that case deals with the fact that the state's revocation of whether it be formal or informal diversion cannot be arbitrary or capricious. Where I hear the state arguing that they wanted the full effect and benefit of informal diversion, I believe that that either binds them or it doesn't. It's either informal, they could pull it at any time if he wasn't participating, or if he was participating, and that's a material acceptance of the term of the diversion. If we're going to go into, contract law that covers diversion, if there was substantial performance on his part, so they need to be bound by it.
And so sorry to interrupt, but you're saying that there was actually an acceptance of the diversion offer.
I think that there was substantial compliance, which would indicate acceptance of the diversion offer, and had Mr. Gold been given the opportunity to call in on the first, I believe he would have accepted the diversion, but it was withdrawn. So, but I mean, that's kind of
in your argument, you're conceding then that you would have had to accepted it, I guess, informal, like the ringing of the contract bell on the first, whether or not he had already taken steps to attempt to comply with it before
he was
informal.
He was owed the opportunity to accept, and I do not believe he was given that opportunity before it was pulled. I believe the basis it was pulled for was that he had not substantially complied, which both the state's position contradicts with.
So he was owed the opportunity based on
The state's representation. So it was an offer that was made good until he was able to appear telephonically on the first. He was not allowed to the court hearing.
the opportunity to withdraw before acceptance. Right?
It can, but it was not withdrawn until the first before he had the opportunity to accept. So
They did have the court hearing on the first, the defendant had failed to call, he didn't have this at time. He later got through to court staff about 45 minutes later. Of course, then that person was taken and several filings of motions which has been transferred back. So you think that we did not have an opportunity, even though we had court hearing and failed to appear?
I don't have a full record before me. All I know is that he substantially complied with the terms of diversion, and the reason that I heard on the audio recording that it was being withdrawn is that he had not substantially complied with the informal diversion offer. I see that as being materially similar to Kramer, where you have someone that is following the terms of the offer, and in that case, it had to do with the defendant flipping off the victim, and that victim then got an injunction against harassment from the defendant. And in that case, the state was claiming that that was not law-abiding behavior, he had not complied. And then the defendant argued that was not a term of the diversion, and therefore the withdrawal was arbitrary and capricious. I do believe here he was complying with all material terms of the informal offer. But like I said, I wanted to brief that separately when I had a full record. My point in bringing that up today is that the state's going to be arguing that he got the full benefit, or it was to his benefit, then they also need to recognize that they withdrew it by saying that basically he had not taken advantage of it at all, which I see that as being fundamentally contradictory.
Thank you, Counsel. Mr. Wilbur, the state conceding that a disclosure violation pursuant to the rules.
Your Honor, we would defer to our motion. And if the court is going to find that disclosure violation, we would still argue that dismissal is not the appropriate extension.
And so then what should be the extension for a Rule 15 discovery violation in this matter?
Your Honor, we would defer to the court on that.
And the court has reviewed the motions from the parties, as well as heard full argument here today. Court finds that there was a disclosure violation in the matter. Court finds that state never filed any motion to suspend prosecution, therefore they, even while going through formal or informal diversionary offers or even completing negotiations, they would still be required to send the defendant the required information. Court finds to be bad public policy if they were to allow the state to offer diversion, but they were withholding the evidence until you make a decision on the diversion offer. The defendant still has the right under the rules to be entitled to receive that information. I find there is a disclosure violation. Don't find that there is a violation of withdrawing the disclosure or the diversionary offer. Like, I find that distinction then between this case and the Kramer case, where there was no formal acceptance while the defendant made them steps. Don't find there was a formal offer. I find that the state was well within its rights to revoke that diversion offer before it was formally accepted. Therefore, I find that dismissal with prejudice is not appropriate, but I can find that dismissal without prejudice is the appropriate remedy for the 10-month-long disclosure violation. I will enter that order at this time, dismissing the charges in this case without prejudice. So anything further from the defense before we adjourn here today?
Nothing further, thank you, Your Honor.
And Mr. Wilbur from the state?
Nothing, Your Honor.
There being nothing further, then we are adjourned. Thanks for appearing. Best of luck going forward. Mr.
Congratulations, Mr. Gold.
Thank you for your.
And so, Mr. Gold, I've dismissed without prejudice. That without prejudice, of course, means that probably your attorney explained the state does have the next 6 months to file again. But at this time, charge are dismissed, case is closed. You have no further responsibilities to the court this time. But best of luck, sir.
Thank you.
Hopefully this scumbags don't try to.
Yeah, I agree. Yes, I agree. I agree 100%.
Good job.
Very good job.
Thank you. That's me, I'm Barry.
All right.
Congratulations.
Thank you. Great job.
Terry, I hope I don't have
Yeah.
to need your services.
Yeah, I hope none of you are ever
Yeah,
clients.
thank you. Yeah, you have a loud booming voice.
Yeah, I don't want you to be a client.
Yeah. Thank you.
very much.
So anyway, out here, guys, this is the view of the fourth floor of the city court. But anyway, all charges that you heard was dropped without prejudice, which means they can bring it back up. So, but Mr. Gold has all the charges dropped without prejudice. I wish it was with prejudice, but yeah. So anyway, all right.
All right, so. Therefore, second, I thought, without prejudice, it should have been a second ago.
Yeah, it should have been with prejudice, but I went portraits because most of this is gonna be audio, that's why I went portrait.
The only thing I did was mention about Edward, they can refile.
Yeah.
I read it, they're back.
Doesn't mean they will refile.
I find it highly unlikely. I hope not. This is a little bit different. The guy's moved out of town.
Yeah, you don't even live in town.
Yeah, so congratulations to Mr. Gold.
They probably won't be.
Very,
Yeah.
very happy for him. Very happy. So,
He had to pay $1,000 a day for security because they kept calling on him. You know,
Oh, it's a win.
Yeah.
for sure.
It's not likely to be right. It is out of town. We had a little talk in this town.
no one else tried to get you to stop?
Nope. I figured him coming out, he was trying to get somebody, but no.
Yeah. Yep, give him.
Still filming? Still filming?
Well,
Still filming?
Yes, live. So anyway, all charges dismissed without prejudice. So we'll see if they're dumb enough to bring it back. They got no evidence. Like we was just noticing down there with Reluctant Prophet. There's a guy the last 2-3 times I was here, he sits out by where we parked and just yells. They don't get him for this early, and he was yelling loud, you know. Downstairs, when we pull up here last 2 times, there's a guy that right behind there that sits there and just yells. And they don't get him a disorder, and he just comes out and farts, and they do Mr. Gold at his house.
That's it, Mr. Gold? That's it?
So, and I've been telling these guys, we're gonna be doing press conferences every time after this, because they tried to stop us. The last 2 times, they didn't try to stop my live stream. So they're kind of learning, but they did. Dick Tracy tried to tell West Side Accountability that she couldn't record, you know, and we was all saying, yes, you can. We're gonna go out here. I'm gonna miss you guys. We're going in the elevator. So, you guys back? Are they jamming us? You guys hear me? Put a 1 if you can hear me. Put a 1 if you can hear me. All right. West Side's going in there. Oh, good. So, yeah, it dipped out when we went in the elevator and it didn't come back for a while. But that is the recorder. Out here, the papers you got, 122.1 don't apply here.
No.
That's what I'm telling them. This is a definite public area before there, because that's the recorder, public.
Where do they get their information from?
Them guys, yeah, yes, yep, you can actually, but they still say you can't. This is where they threw me out with NMN right here. They wouldn't let me live
I
stream.
can even do a FOIA request in there if I wanted
Yeah.
to.
Yeah, but they stopped doing
Their
that.
papers back.
Yeah. Here's 122 and 122.1, guys. So they're actually starting to follow it finally. You know, this is the place where I'm sitting right now, where they threw me out of. So
Have you had any updates yet, Anna, filed any paperwork yet?
no, I don't know yet. I don't think so.
Yeah, 'cause that's why I'm here too, because I didn't like that they put their hand on her at all.
Yeah, no one
He
did.
was lucky I
And they
didn't
did
do
it.
the camera.
Yeah, they did it right here.
Yeah.
You know. So, yep, we're out.
Yeah.
Yep. They're not doing nothing.
No, you can't.
No, I finally realized. All right, guys. Did I hit you? Yeah. I hope they didn't. All right, guys. A win's a win.
I don't care what anybody says. That was
Definitely a win.
And they didn't stop us from recording.
They didn't
tried.
stop, that's even a
They
bigger
tried.
win. They came
This
up
is
and
the second
threatened you guys
time.
and you stood your ground.
And this is the second time. Second time they didn't stop us from recording. They tried to stop, Dick Tracy tried to stop West Side Accountability, but it didn't go very far.
But you just can't do it here. We said, yes, you can.
Yeah, you can.
Hey, you thought
Yeah.
I was gonna budge. I didn't even.
Yeah. That's Dick Tracy. You met Dick Tracy,
I mean,
the famous Dick Tracy. All right, guys. Thanks for coming in. I'm going to get out of here.
I wonder how much that poor guy paid in attorney's fees to get that.
Well, before, this is
So
the
that's when I say it's not a win.